You know, when a lot of us think of the Philippine Constitution, it's pretty easy to just picture a dusty old document sitting behind glass in an archive somewhere. But the reality? It is far more dynamic than that. The Constitution is literally a living, breathing rule book. It steps in exactly when our societal rules are tested the absolute most. We're talking about everything from a rapid-fire dispute over a local union election, to a massive legal challenge aimed at the highest officials in the land, to foundational cases like the absolutely groundbreaking Oposa v. Factoran, where the rights to a balanced ecology actually took center stage.
And that brings us to this incredibly powerful quote from Justice Kapunan. This was delivered during a really highly charged Supreme Court case involving a former president of the Republic. This quote essentially sets the dramatic stakes for the entire legal system. Because at the end of the day, the rule of law must apply neutrally to absolutely everyone, even to those society might be really angry with at the moment. It doesn't matter what the public clamor is, justice has to be blind to personalities, completely unswayed by the passions of the day, and focused entirely on fundamental fairness.
So here's our roadmap for today. 1. Equal protection and classification. 2. Due process and vague laws. 3. Exhausting administrative remedies. And 4. Quo warranto versus impeachment. Let's get right into the foundational rights of the individual.
Section 1. Equal protection and classification.
Okay, so it's a bedrock constitutional principle that the law promises equal protection to all citizens, right? But here is a really fascinating twist. Treating groups differently is actually sometimes perfectly legal and constitutional. Wait, what? Well, it's not always about treating everyone exactly the same. It's about treating equals equally. And to evaluate that, the Supreme Court uses this really strict four-part checklist derived from the landmarked Kayat case. For a law to actually survive an equal protection challenge, it has to hit every single one of these marks. No exceptions. First, the classification has to rest on substantial distinctions. Second, it must be germane or, highly relevant to the actual purposes of the law itself. Third, it can't just be limited to existing conditions only. And fourth, it must apply equally to all members of that newly defined class. Basically, if a piece of legislation fails even one of these requirements, boom, it becomes unconstitutional discrimination. It is a very strict, highly logical test.
Moving on to Section 2, Due Process and Vague Laws.
Let's shift the narrative here to the idea of fair warning. It's basically the concept that a law cannot be a hidden trap for citizens. I mean, you can't possibly be expected to follow a rule or be punished for breaking it if you literally can't understand what the rule actually prohibits, right? That brings us to the void for vagueness doctrine. This means laws must be explicitly clear to avoid arbitrary punishment. If a person of ordinary intelligence has to just guess at a law's meaning, that law is fundamentally unfair. And this exact doctrine was famously invoked as a massive stress test against the RA 7080 anti-plunder law during the trial of former President Joseph Estrada. The whole legal argument centered around whether terms in the law, like combination and series, were simply too vague to give an ordinary person reasonable notice of what actually constituted the crime of plunder.
But consider this. What if a law is perfectly clear, but it just simply goes way too far? That brings us to overbroad. An overbroad statute might be super easy to understand, but it accidentally criminalizes your constitutionally protected rights along the way. For example, a law aiming to keep public spaces clean by prohibiting all election propaganda anywhere, even inside private vehicles, was struck down. Why? Because it deprives citizens of their free speech right to put a sticker on their very own car. So, to contrast the two, vagueness is a total lack of clarity, while overbreadth is a clear law that just sweeps up way too much protected freedom in its net.
All right, Section 3, Exhausting Administrative Remedies. Let's look at the procedural mechanics.
So, we've covered some pretty abstract constitutional rights. Now let's step away from the high stakes of the presidency for a second to look at a real-world labor dispute. To really grasp this, we first need to define an intra-union dispute. As you can see, it's any conflict between and among union members, specifically including grievances over the internal constitution and bylaws of that union. Now, why is getting this specific definition right so absolutely crucial? Because the law dictates that the Bureau of Labor Relations, and not just your regular everyday trial courts, holds original and exclusive jurisdiction over these highly specific internal conflicts.
Now, to see how chaotic this can get in practice, just look at this incredibly rapid succession of events from the Flames Supervisory Union dispute. Talk about a time crunch. On May 5th, certain union candidates were directed to file an answer to a petition that was seeking to disqualify them. Okay, so on May 6th, the very next day, they filed that answer. And on that exact same day, the union's election committee immediately issued a decision officially disqualifying them. And then, the very next day, May 7th, the union elections were held.
So normally, procedural law strictly requires what's called exhausting administrative remedies. Basically, you have to climb the internal ladder and use all the internal appeals within your organization before asking the government to step in and save the day. But the law is smart and it adapts. That rule can be bypassed when resorting to those internal remedies would be totally illusory or vain. Connecting this back to that crazy timeline we just looked at, those disqualified union candidates literally didn't have the time to use standard internal appeal processes before the election actually happened. Following standard procedure became practically impossible for them, which is exactly why their jump directly to the Bureau of Labor Relations was entirely legally justified.
Which brings us to Section 4, Quo Warranto versus impeachment.
We are shifting now to the absolute ultimate constitutional checks on public officials. We're going to neutrally explore how leaders are held accountable when their very right to sit in their office is thrown into question. But before we compare it to a much more famous governmental mechanism, we have to ask, what actually is quo warranto? Well, it is a specific legal remedy. Its entire purpose is to determine a person's right or title to a public office by inquiring into their initial eligibility. Essentially, it's a judicial process asking the question, by what legal authority are you actually holding this position right now? And its ultimate goal is to oust an unqualified holder.
Let's walk through this direct contrast to demystify what has been a highly debated Supreme Court ruling. We are impartially looking at the structural differences between these two mechanisms here. On the left side, quo warranto focuses purely on a public officer's initial eligibility. Did they even possess the required qualifications when they were appointed? If not, it grants the legal relief of ouster. On the right side, impeachment focuses on a public officer's behavior and actual offenses committed while they are actively serving in office. It affords the penalty of removal. So, to put it super simply, one addresses whether you were legally qualified to get the job in the first place, and the other addresses how you behaved once you were actually sitting in the chair.
Now, as you might guess, there are strict rules governing these mechanisms. Usually, there is a strict one-year prescriptive period, basically a ticking clock, for filing a quo warranto petition. But the court established a major exception here. This one-year timer does not apply when the petition is filed by the state at its own instance to protect the public interest. The Supreme Court essentially ruled that when the state itself acts directly to protect the integrity of the Constitution, that standard ticking clock just does not apply.
And that brings us to our final provocative question for this explainer. When the ultimate rules of society are tested, who truly holds the scales? We've journeyed all the way from the foundational rights of the individual against vague and overbroad laws. We've navigated the rapid-fire mechanics of procedural justice and labor disputes, right up to the Supreme Court's most powerful remedies for holding the absolute highest officials accountable. The legal system really is a constant dynamic balancing act. I hope this structured look at these legal mechanisms has left you eager to explore the living rulebook of the Constitution even further. Thanks for joining me.